I'm
And
just
I
gonna
will
go
be.
put on a sweater so I'm dressed more appropriately. We've had a heat
Oh.
wave here, so I've been like dying.
No worries.
Air conditioning. So
Oh, that's right. There's like a weird heat wave in the northwest.
That's right. And a lot of times it comes off of Hawaii. Those heat, oh, what are they called? It's called Pineapple Express.
Huh.
oh, okay.
Yeah. My husband's family told me about it. Can you see my screen?
I can.
Wonderful. And you don't see the video box, right? Where we have. And also, I'm going to join on my device just to keep an eye out for comments. And Caroline, if you are able just to keep an eye out for comments, or if people need to go back to a slide, just interrupt us, let us know.
I'll keep an eye on comments. If you put your device too close, you'll get a lot of feedback.
Is there any feedback?
I don't
Not so
hear
far.
any.
You sound good.
Okay, great. Good morning, Rebecca. Good morning, Aurora.
Good morning.
Good morning. And feel free to get some water or coffee, make yourself comfortable. Good morning, Crystal. We'll be starting here soon at 10:05 so people can log in, log on. And I'm going to make Pat a spotlight so everybody will be able to see her. So spotlight for everyone. And then we'll turn off cameras so connectivity is a little bit better. And we'll just give it a couple more minutes and then we'll begin with setting our intention and moving into the slides. Okay, I'll go ahead and begin sharing, and as people join, we'll welcome them in. And the recording, or this webinar will be recorded, so anybody who has missed can get the recording as well. So good morning, welcome. I'll go ahead and screen share here. Good morning. We'll begin offering a land acknowledgement to our ancestors and to those people who allow us to do this work on the Dena'ina land. I live and work on the land of the Dena'ina people. Welcome. So this morning we'll go ahead and set our intention. So just taking 1 minute to think of something that you are hopeful for the future. If that's in your community, for your tribal council, for your children, just closing your eyes and thinking of one thing that you are hopeful for and setting your intention and reflecting on that intention throughout this webinar. Some pieces might be overwhelming or that you want to move quickly, and referring yourself back to that intention. What is one hope for the future? Okay. Please put your name in the chat box, where you're calling in from, and your email address. We'd like to make sure that anybody in this room also gets the recording and the survey, of course. So your name, where you're calling in from, and your email address, please, in the chat box. Good morning, Nathan. I see that you joined. We just set our intention, and our intention is one thing that we are hopeful for the future. And in the chat box, just putting your name, where you're calling in from, and your email address. And one of my favorite things about webinars and when people are putting where they're from is to see where everybody, across Alaska is calling in from, and it's a beautiful thing. Wonderful. And I'll keep an eye out for the chat boxes people are joining. And of course, as always, we welcome them as they are at the time that they are. And thank you to our funders, VJA and OJJDP, allowing us to do this work and funding us as grantees as well, just as you might be grantees. And Caroline, go ahead and take it away.
Jamai, I'd like to talk a little bit about what Alaska Tribal Justice Resource Center is. Our program started in 2019 with funding awarded from the Bureau of Justice Assistance from the Coordinated Tribal Assistance Solicitation Grant. Our funding allows us to serve grantees receiving the Purpose Area 3 CTAS funding for tribal court enhancement, but our funding also allows us to serve non-grantees as well, to provide training and technical assistance to enhance your tribal courts, your tribal police, and your tribal corrections and reentry programs. Our program operates under RuleCap as a nonprofit. Our mission is to develop a collaborative atmosphere of knowledge sharing to provide training and technical assistance to Alaska tribes, professionals, and promote greater self-governance and community sustainability and leadership.
Thank you, Caroline. And my name is Ashley Anderson with the Resource Basket, also under RuleCap as another training and technical assistance program, just like ATJRC. We are an access to a network of youth serving organizations. We offer program guidance and peer-to-peer exchanges, supporting our grantees funded under OJJDP. We offer different trainings such as this one. We also go to different trainings regionally, statewide, and nationally. We are a support agent so that none of our grantees ever feel alone in the work that they're doing. And we offer expert technical assistance, just like Judge Pat and other experts, so that they can help provide you the information you need for your juvenile healing to wellness courts, which is Purpose Area 8, and the Tribal Youth Prevention Programs, which is Purpose Area 9. We also serve community partnerships. So if someone reaches out and says, we're looking for a webinar or need a certain item around these programs, we could offer that as well. Our mission, The resource basket supports Alaska Native communities and service providers as they grow healthy, successful, and culturally connected Alaska Native youth. We are a team devoted to improving the lives of Alaskan youth. Now, we are going to take a quick poll. And so if you've just joined us, please put your name, where you're calling in from, and your email address in the chat box. And using the chat box, we have just kind of a few guiding questions to see what we need to emphasize on today, and maybe what we need to skip over. Maybe all of you already have a family wellness court happening. The first question, and you could just simply put yes, no, or maybe. Do you plan to apply for funding for a family wellness court? So a couple of maybes. And we hope today that you feel more prepared to be able to apply for those things. So possibly, yes, thank you, Crystal, for letting us know. Okay. Do you plan to apply for funding for a family wellness court? The next question. Do you currently handle child maltreatment cases, also known as ICWA cases, in your tribal court? And if you do, about how many a year? Just best guess. And Nathan says not at this time. So again, maybe perhaps this training can help guide you to that point. Thank you, Crystal, for letting us know. And Janae says, not sure how to even guess how many at this point, and that's okay. And the final question, does your tribe intervene in state court ICWA cases? How many year? Best guess. Rebecca says we are learning how to. Crystal says no clue. That's okay. And Caroline, if you are able, please go ahead and put that solicitation into the chat box. Thank you, Caroline. Caroline just put in the chat box a solicitation for the funding through OJJDP, which is for the Family Healing to Wellness Court funding. That will be open until June 20th. It is closing June 20th, 2023. And we also encourage you to apply even without a match. They do have match waiver requests. The closing June 20th, an encouraging application without a match, and they do have the match waiver requests. So welcome to the Tribal Family Healing to Wellness Court, FHTWC Model 101 with Judge Pat. Go ahead, Pat, take it away.
Okay, great. Welcome everybody to our training this morning. I'm hoping to be able to share with you some of the modeling that we're doing at Rural Cap, because we're seeing an increasing interest in the family healing to wellness court model that tribes in Alaska are interested in developing. So without further ado, let's go ahead and go on to the next slide. Okay, so we have a pretty chunky set of slides to move through today, and I'm trying to get some sense of where you all are. Of course, this is grant writing season, so we're all trying to understand how to describe what we think it is we want to do. But there are some preliminary things I want to talk about before we hit the model. And the first is I wanted to talk a little bit about how Alaska is different and the same as tribes in the lower 48 states. Why am I doing this? Because healing to wellness courts have multiple audiences in order to make them work, and maybe multiple audiences here today as well. So these healing to wellness courts are run by teams of professionals who are interdisciplinary. So some of the members on the team are tribal court staff, like judges and court administrators and coordinators, and then some team members come from the treatment professions. Some team members may come from the education profession, and we don't all understand each other's professions or ethics or processes. So it's always a cross-training environment, and the audience is always interdisciplinary in terms of profession. Also, many tribal healing to wellness courts are joint jurisdiction, meaning that they coordinate between the state government and the tribal governments. And so we may have audiences that, and when I say audiences, I mean for this presentation, but also team members who come from either a state system or a tribal system, which can be really different. And they also may be native and non-native or from many different cultural backgrounds. So we have a very interdisciplinary and multicultural audience, both in our teamwork and probably also in our participant populations to a certain extent. Also, it's possible we may be talking about intertribal healing to wellness courts, and then always we're contrasting how we set them up in Alaska versus how we set them up in the lower 48. Okay, let's move to the next slide. So I taught at University of Alaska Fairbanks for a while, and I would say about 80% of our students in our programs were Alaska Native. And they seem to benefit quite a bit from this diagram. So this is a diagram called the non-system of entities in rural Alaska. The term was coined by David Case and David Volokh in their book, Alaska Natives and American Laws. But for our purposes, for wellness court purposes, it's important to point out that there are multiple entities that are involved in supporting a tribal court system. In particular, a tribal healing to wellness court. So of course we have our tribal governments, right, in the tribal government bubble here. Some of them are traditional councils. Some of them are what we call Indian Reorganization Act councils. Then of course, Tlingit and Haida Central Council got its own federal legislation separate from the others. But the point is we have tribal governments. They're sovereign, they have inherent governmental powers. Now, if we look at the state bubble, we'll see that some of the villages in Alaska also organized state municipalities that sit side by side with their tribal governments. So we have different kinds of native government. And then we also have two home rule boroughs, right? The North Slope Borough and the Northwest Arctic Borough in Alaska. So the point is there's multiple layers of government that have to work together to make a court operate. Now, remember, we also are integrating treatment into these healing to wellness courts. So that means we have to also think about the regional Native nonprofits and the Alaska Native healthcare system. And as you can see, there's a whole bunch of regional Native nonprofits that may be responsible for contracting for treatment services, maybe VPSO law enforcement services. So we have to think about these entities also in planning a tribal healing to wellness court. Okay, let's go ahead and bump to the next slide. By the way, if you all are sort of thinking of questions along the way, feel free to just pop them into the chat and Ashley will prompt me to answer them. And Ashley, feel free to just sort of pipe in and let me know if there's a bunch of questions in there.
I will, absolutely.
Okay, so I wanted to go ahead and move to the next slide. Talk about nation building for a moment and an observation made by the folks at Harvard, which is interesting and profound. Go ahead and move to the next slide, Ashley. So the Native Nations program at Harvard was looking at tribes that govern well. And they noticed a difference between what they call self-governance and self-administration. And they said there's a profound difference between these things. If you're merely self-administering, you're just getting federal grants and implementing federal grants as they pop up, you're just doing self-administration. Someone else is in the driver's seat. But if you're doing self-governance, you are a Native nation that's seizing authority and governing to do certain things, to assert your rights and capacities to reshape your nation according to your own design. You have some master strategic plan for where you want to go with your governance. You have been maybe making and enforcing laws that promote your high need areas and your values. You are developing and pursuing long-term strategies of community development. And in doing so, you're negotiating new relationships with other governments. You're acting like a government, working with other governments. And you're doing this, exercising meaningful jurisdiction over lands and peoples within your borders. And so you're governing, right? But you're doing it the way that your people value and promoting your top priorities. So I did want to point out that a healing to wellness court can be a profound part of self-governance that's focused on getting people well. Not just people, but their families and your community as a whole. And if you see it in this larger light, it's a very important thing for many of our tribal communities. Okay, let's move on to the next slide. Okay, I should just say a little bit about me. I meant to do this at the front. And so I am a tribal appellate judge. I'm the Chief Justice of my tribe's appellate court on the Hopi Reservation in Arizona. And I've also worked as initially a law clerk, a pro tem judge. I've been working with my courts for about 30 years, and we did launch a wellness court, a juvenile wellness court, and we sort of saw it from beginning to end and then ran out of money, and now it's starting back up again. So a lot of my observations in this presentation are given my experience back home. Also, I am a modeler. I look at the like the different kinds of tribal courts that you could set up, and I think about what would be more useful for different purposes. Different tribes have different purposes. Okay, so I wanted to just say a little bit about the Indian Law and Order Commission's 2013 report. Some of you may recall that Congress established this Blue Ribbon Commission to go back and look at both public safety and law enforcement in Indian country in 2010. And after going around the country, meeting with tribes, even in Alaska, the commission issued this report in 2013 and called for greater tribal control and accountability, especially with respect to tribal courts. And they did have a whole chapter dedicated to Alaska. In it, they noted that then, this is in 2013, that there were 78 operating tribal courts in Alaska, and that the tribal courts here were really limited by funding constraints and narrow jurisdiction. You all up here were not getting the same amount of money that tribal courts in the lower 48 were getting. And of course, there were sort of heightened level of jurisdiction challenges up here. Nevertheless, your tribal courts were functioning, and they found that the cases in 2013 they were seeing were child welfare. That's like, you would think of them as child maltreatment cases where somebody is alleged to have done abuse or neglect or that kind of case. Customary adoptions, public drunkenness, disorderly conduct, and minor juvenile offenses. So this is really sort of a small subset of all the things a tribal court can be doing. Obviously, criminal prosecutions are not on here. And that's a big sort of other side of what tribal courts in the lower 48 are doing. There's a lot of reasons for this, which we can talk about if it pops up in our conversation going forward. Okay, let me just stop here for a moment. Okay, I'm going to go ahead and go to the next slide. So let's talk about tribal healing to wellness courts. What the heck are they? How do they work? What are the different types? Ashley, can you move us to the next slide? So there's multiple names for tribal healing to wellness courts. The first thing they were called were drug courts. And in the state system, you still see them using this name for the most part. Other names, therapeutic courts, tribal drug courts. Those of us in the native TA provider world call them tribal healing to wellness courts or wellness courts. And the acronym is HTWC, Healing to Wellness Court. They come in different flavors. Some of them focus on adults who are coming from a criminal docket, court docket. Some focus on family issues, parenting issues. Some focus on juvenile delinquency is what they used to call it, but where the young person is engaged in behaviors that are pulling them into the justice system. Some are focused on DUIs, others on veterans, others on reentry. The most common types and the types that I'm going to talk about today, we're going to focus on family, but also juvenile and the adult criminal model. So in Alaska right now, there appear to be 10 tribal healing to wellness courts. 3 are adult, 1 is family, and 7 are juvenile. And we see another sort of crop of juvenile and maybe adult popping up under the next grant cycle. So this number will increase, but it'll also vary as they sort of, as tribes figure out which dockets or types they want to develop. Okay, go ahead to the next slide. So who gets into a tribal healing to wellness court or a wellness court? It depends on the type of court you set up, but generally these are the things that will get you in. So a participant, a young person who's alleged to have committed a juvenile offense, that's one kind of category. An adult charged with a crime or a juvenile charged with a crime. Any person alleged to have committed child maltreatment, that's a parent. I probably should have put parent on that bullet. And they have been screened to have a substance use or abuse problem. So wellness courts are targeting people who have substance issues. They have these other conduct issues, but right, they also have to have a substance use issue. Otherwise, why would you put them in a wellness court that's all about substance use treatment, as well as other things? Okay, let's go to the next slide. Now, I could spend 2 hours talking to you about the history of Alaska tribal court jurisdiction. And I'm not going to do that because we need to get you on to the family wellness court model. But I will say this, tribes in Alaska have inherent sovereign powers and jurisdiction. They have both civil and criminal jurisdiction over their members, including those eligible for membership. And under the recent Violence Against Women Act amendments of 2022, Congress has reaffirmed that tribes in Alaska have both criminal and civil jurisdiction over all Indians present in the village. And a select number of pilot tribes will also have some criminal jurisdiction over some non-Indians. So it's a complex question here, but for wellness court purposes, tribes have jurisdiction over their members, and they have jurisdiction over Indians in the village. Now, my colleague Alex Cleghorn points out that under VAWA, villages is defined by those listed in the Alaska Native Claims Settlement Act. Okay, I know that's a big ball of information there. Just hold on to that, and when we do Q&A, you can ask me more questions. Ashley, are there any questions so far?
Not that I'm seeing in the chat box, and always feel free to use the chat box if we need to go back to a slide, but no questions at this time.
Okay, thanks. Okay. Tribes in Alaska are more likely to want to establish juvenile and family to healing to wellness courts. And this may be, this conversation may be something that I'm projecting out to those members of your team who either are not from Alaska or are in the state system. Or maybe they're in the national drug court movement and they don't understand, why aren't you doing a lot of criminal jurisdiction in tribal court in Alaska? Well, there are some reasons why not. First, the federal government funds do not fund healing to wellness courts that target violent offenders. So those, if you were going to target them for wellness court, which, by the way, the National Association of Drug Court Professionals says you should target some of these people for wellness court, you can't do it under your federal dollars, under CTAS or OJJDP. So that's a reason why tribes don't do that with their federal dollars. The second is that there are erroneously perceived limits on tribal jurisdiction in Alaska, and this often curtails the exercise of tribal criminal jurisdiction. Can tribes do this? Yeah, some of them can. Do they do this? Many don't because of number two. Should they do it? It's up to the tribe, and some tribes will exercise criminal jurisdiction. I'm not saying you can't. I'm just sort of observing that many don't. Three, Native juvenile adult offenders tend to start out in the state juvenile and criminal justice system first in Alaska. And because of that history and the state's sort of central role in dealing with this population, tribes haven't historically done it first. So in a lot of cases, we're talking about moving those folks out of the state system into the tribal system, but they're starting out in a state criminal or juvenile system. And then fourth, there's a great need to deal with Native adolescents and parental substance use and mental health disorders. That maybe I should have put that as number one because that's a huge need. I see Caroline raising her little yellow hand.
Thank you. I was just wanting to point out that we have a question in the chat, and the question is, does the tribe have criminal jurisdiction outside of the village? Is there still criminal jurisdiction outside of the village?
Probably not. Now, if you're one of those pilot tribes that's exercising that special jurisdiction under VAWA, I'm going to put a big asterisk by that because that would make you different from all the others. And I would say no as a simple answer. Now, do you have trust lands outside of the village? That's a big question too, because then it might be a different answer. Yeah. Oh, and I should say, if you have questions or topics that you want to come back to Rural Cap with later, either for us to do another a webinar series or just to do some TA with us, please let Caroline and Ashley know. Okay.
Thank you, Pat.
Yeah, you're welcome. Next slide. Okay, so let's talk a little bit about the family treatment court movement or the family drug court movement. And I'm going to talk about in the next 2 or 3 slides about the national movement. Go ahead, Ashley. Let's move to the next slide. So one observation at the national level is that the whole country is facing serious challenges in addressing the number of children that are in out-of-home care because of substance use problems of the parents. That is happening everywhere. And I just did a quick search of newspaper articles in Alaska, and I came up with this KTOO article in 2022. There's a class action lawsuit in Alaska that is arguing that the state is failing foster kids. So don't think this is just native Alaska, it's the whole country. Okay, let's go to the next slide. So family treatment courts, they have, so the whole model of the family drug court is to do certain things. One, the goal is to reduce child maltreatment. We don't want our kids being abused. Nobody wants that. Also, to reduce the length of stay of children in out-of-home care. Not only does nobody want kids away from their families, and we also want them to be safe, but also governments and taxpayers don't want to pay for all of that either, right? So some of the longer term goals of family treatment courts are to reduce child maltreatment and reduce the length of time that kids are in out-of-home care, but also to help families achieve reunification with their children, and also improving treatment and recovery outcomes for the parents in these families. Okay, go ahead and go to the next slide. So there were a number of studies done, and I'm just going to give you some of the gist of it nationally. And they were looking at kids who experience abuse, neglect, and time in foster care, and they noticed that they are at a higher risk of certain negative outcomes. So first off, half of the youth involved in child welfare had significant emotional or behavioral problems. And studies have also found that youth who are in foster care tend to have more mental health problems than youth who are not in foster care. They're twice as likely to have conduct symptoms. They're 4 times more likely to report suicide attempts. They're 8 times more likely to report anxiety, 7 times more likely to present with disruptive behavior disorders, and 5 times more likely to receive a drug dependence diagnosis. Also, adverse childhood experiences related to abuse, neglect, and dependency are also linked to an increase in delinquency and crime. Also, these kids are less likely to graduate from college. So the research on having kids in foster care is pretty scary. We don't want our kids with abuse and being in foster care because it just sets them up for a very rough life, and it's filling up our detention and prisons and jails also. The percentages, if you look on the right hand side of this slide, the percentages of American Indian and Alaska Native children among foster care and child populations for the 10 states with the largest proportion of Native children are these. And you can see Alaska is ranking at number 2. So what is this saying? It's saying that 53% of children, the percent of foster care population that is American Indian, Alaska Native is 53%, yet there are only 12% of children in Alaska, I'm sorry, I'm looking at South Dakota. Alaska is 47% compared to 18%. but it's no good to be number 2 on a bad list. My state, Arizona, is also on here a little lower down the list, but a lot of these states are states with large Native populations. You know, as I've done this work with tribes, and I've also looked at the state, the people involved in the state justice systems, you start to notice that a lot of the youth and the adults that are caught up in the state justice systems are people of color. And in states with large Native populations, it's a lot of Native people in the state systems. And to me, this is an argument for tribes to work closely with state government to look out for our people. Even the people that some in our community would consider lost. They're still our family members, and we've got to ask the question, why are so many of our family members caught up in the criminal and juvenile justice system? And also they're going to come back to our communities. So we just can't kind of avert our gaze from them and say they're lost. And many of us have family members that we love and we don't want to lose them. So it's important to know these stats. This is the national information, but yet it comes back home to us. Okay, let's go to the next slide. So do family drug courts work? They're always researching this question for every type of drug court. And there was a meta-analysis of 16 evaluations examining family treatment court outcomes. And they found that families that participated in these kinds of drug courts were 2 times more likely to reunify than those who just got the regular stuff. Also, in prior evaluations, they found that, I'm just going to look at my notes here. Parents participating in family treatment courts entered treatment more quickly. They tended to be retained in treatment instead of just quitting. They completed treatment at higher rates, and they were more likely to be reunified with their children. The children of parents participating in family treatment courts spent less time in out-of-home placement and entered permanent placements more quickly. And a permanent placement could be back with their family members or it could be adopted. But clearly the family treatment courts are doing something better than the regular children's court system in the state systems. Okay, let's go to the next slide. And let me just check my time here. Okay. All right, so I would like to look at the modeling next for tribal family healing to wellness courts. But before I do that, let me just pause for a minute. Are there any other questions that folks might have so far? If you think of some, yes, go ahead.
There are no questions in the chat box.
Okay. I'm not real good at watching the chat and talking at the same time. All right, let's go to the next slide here. So some of you, and I'm definitely one of these people, are visual learners. So you need to see the roadmap or the diagram. And so I put together this both model and diagram of what sort of a full-blown tribal court would look like with a family healing to wellness court inside of it. And so let me just take a minute and describe what the standard tribal court might look like. So if you look at the boxes on the top of the diagram here, across the top, you see children's, juvenile, and criminal. These are dockets. And in tribal courts in the lower 48, these are the different kinds of cases that show up in tribal court. And what a docket is it's just a schedule for when the hearings happen in tribal court. So, for example, the criminal docket, those are where, you know, somebody's alleged to have committed a crime, and usually those are scheduled on Mondays because everybody's been out partying on the weekend and getting in trouble, and they're arrested over the weekend and they're sitting in jail in a tribal court in the lower 48. And on Mondays, they schedule all the criminal arraignments. So that is a criminal docket. Now, it may be on Tuesdays or Wednesdays, they schedule the children's cases, right? The child maltreatment cases. Maybe they schedule juvenile cases on, I don't know, Thursdays. But the point is, the word docket is just schedule. It's when the judges who do those kinds of cases are scheduled to hear them. Now, family wellness courts are another kind of docket. And as you can see, the particular type of wellness court comes with a particular type of docket. So children's cases in the children's docket, those go to family wellness docket. Juvenile cases go to juvenile wellness docket. Criminal cases can go to an adult criminal wellness docket. And as I've explained, in Alaska, we see a lot of interest in juvenile and family docket for wellness court. So let's say your tribe gets, let's say there's a parent who is alleged to have neglected their child. They're out drinking, they've left the kid at home for 4 days, not checking on them. It's a small child, and somebody reports this to the tribal court. And so the tribal court puts it on the calendar, on the docket. They hold a hearing to, hear what's going on here. And of course, they've picked up the kid and made sure that the kid is safe. And then they learn more about the family and they think, oh, this parent maybe would be a good candidate for the family wellness court. And so then they transfer the case out of the regular tribal court docket down into the family wellness docket. And at that point, we move to the bottom of this diagram. So how do we know if somebody should go to a family wellness docket? Well, they need to be screened both legally and clinically for eligibility. Are they a violent offender? If yes, they're not eligible. Do they have a substance use disorder? Yes, then they're probably eligible. If they're eligible, then they come down to the bottom of the diagram and they're admitted into the wellness court program by the team and the judge. And then we start going around and around in this circle. So first, they're assessed for a treatment plan, and a treatment plan is put in place. And then the program sets up phases of both treatment and other activities and services that the individual will move through in the program. And it goes from months to maybe more than a year of phases that they're moving through. Inside of those phases, we see that there's case management with wraparound services. So that means that you have staff in your wellness court who are meeting with them to figure out what they need. Do you have a house? Do you have a car? Do you have food? Do you have a job? And they're helping facilitate problem solving those things and referring people to services. Also, as a fundamental part of the wellness court model is random alcohol and drug testing. And the purpose is not to punish, it is therapeutic, because people who have drug and alcohol problems have reported that this was a very important part of their recovery, knowing that someone was holding them accountable with the drug and alcohol testing. In addition, all of this is reinforced by weekly team meetings and weekly status hearings, where everyone who's in the program, in the traditional model, all the participants would go to court at once in the same hearing, and they'd watch each other get handled by the team and the judge. And in that hearing, the judge is not trying to find if somebody is guilty and punish them. No, the judge is looking at their treatment plan and their phases, and the team is advising the judge whether they're doing well or they're having challenges, or if they're failing their drug and alcohol tests. And then the judge and the team are giving out incentives or sanctions in response to how each participant is doing. And if they're doing well, they get rewards. If they're doing, if they're getting positive tests, they may get a small sanction, and sanctions are graduated. So small failures get small sanctions, bigger ones get bigger sanctions. And the whole point is to keep supporting a person through their treatment plan. Eventually, someone will graduate from the program, or they drop out, or they're terminated from the program. Like if they commit a crime in the middle of all of this, or I don't know, maybe there's another instance of child abuse, then they can be terminated from the program. In which case, they can either be ordered back to the regular tribal court docket, or they can be reported to the state justice system. If they graduate, they're free to go. Some courts will wipe the court record. There's no reporting to the state justice system. So if I step back from this, what seems really obvious to me is that how is this different from regular tribal court? Well, you're putting a whole team of people together to support each individual in this process that might not be there in a different regular court system. And it's all therapeutically calibrated so that it's not about punishment, it's about behavior modification. You're reinforcing things that are good for them, and you're sanctioning things that are bad for them to help them modify their behavior and sort of learn how to be in recovery. Okay. I see a lot of
Judge Pat, there is a question in the chat box.
Sure.
And the question says, for the Family Healing to Wellness Court, is it usually a requirement that one of the parents are also struggling with substances?
Yes. Yes, that's the whole point of it. And it's the parent, the whole family ends up in this wellness court process, but it's the parent that has the substance problem that is pulling the whole family into the wellness court. They are the main, we call them the participant in a wellness court. You know, in a regular tribal court, they might be the defendant or the party, but for us, it's the participant. So yes.
Judge Pat, and then in about 5 minutes, did you want to take just a quick 3-minute restroom break? It'll be 11 o'clock on the hour in 5 minutes.
Sure. And I see Janae raising her little yellow hand.
Hi, can you hear me okay?
Sure can.
Okay, thanks. I just wanted to clarify because, you know, we have a youth wellness court and we're hoping to open up to family court in the future. So I was just thinking of one of my participants in general who's a youth who has substance use issues. As far as we know, the parents don't have substance use issues, but they do have mental health issues that are needing to be addressed. So that's kind of where that question was coming from. So I was curious if there's any like kind of leeway on that, where it would still be beneficial for the family wellness court based off of the youth, but yeah, providing
that's
mental
a good
health.
question. Yeah. So what some tribes are doing, and some states as well, is they have both dockets, the juvenile and the family, and they sandwich them together in their joined wellness court. So in that scenario, your young person and their family is in the wellness court, but they're coming in under the juvenile docket. And parents are coming in under the family docket, but it's all one program. So yes, that you can do that, and that is fine. Okay, let me say one more thing before we break. As you can see, there's a little blue arrow on this diagram that's talking about cultural interventions, historical and intergenerational trauma, and circle process. You can include these in your phased program of your wellness court. It goes into the phases. It's not part of the individualized treatment plan per se, unless you have counselors working on trauma. That goes into an individualized treatment plan. But you can have other activities. I know some Some groups do workshops on history and intergenerational trauma. I mean, you could do workshops on tribal history if you wanted to, and put them in the phased requirements of your program. So what's beautiful about this model for tribes is you get all the bells and whistles of the latest what is known as addiction treatment, and you can culturally tailor it and you can have the best of both worlds in your system. Now there may be dollar signs attached to this, but that's why we go after the federal dollars and we just put it in the right places. Okay, Ashley, I can take more questions on this after the break if people want to. Just, Ashley, you let me know either way.
Great, and no other questions in the chat box at this time. And Janae says, I see. Okay, thank you. We'll go ahead and Judge Pat, is this a good time for us to take a break?
Sure.
Just a quick 3-minute break. So everyone go ahead and take your quick 3-minute break. We'll convene here back at 11:01. And so you could get some water, use the restroom, pour yourself another cup of coffee or tea, and I'll set the timer. Okay, we are back, and I hope you had some time to take good care of yourself. And Judge Pat, would you like me to move it to the next slide?
Yes, please. All right, so I don't know how many of you are grant writers, but if you are, one of the things they'll ask you to do is to propose what your long-term goals are for your tribal court. for the grant you're applying for, and we're assuming it's a wellness core grant here. And these also go into your logic models, that scary thing that looks like it doesn't make sense to you or me or anybody. But I'm going to give you the long-term goals of a family healing to wellness court here. So the first set of goals are to increase child safety, right? You want to reduce the incidences of child maltreatment. The second is child permanency. This is about placement, right? Are you reunifying the young person or the child with his or her parents, or are they getting put up for adoption? There was a big old national debate about this in years past, and Congress wanted to see kids getting to permanency. Don't leave them in foster care. Foster care is bad for kids. Make sure you get their families fixed and get them back with their parents, or get them out in an adopted permanent family. So that's what permanency is all about. The third is to increase the number of parents and guardians who remain alcohol and drug free. And that's the wellness court aspect here. Reduce the number of alcohol, drug involved parents and guardians in the state of Alaska child welfare and criminal justice systems. The reason this goal is in a tribal court grant is because so many of our Native family members are in the state system. Now, should we be held accountable for, in some ways, doing the work of the state system? Some of these goals can be modified by your team. Well, actually, they all can be modified by your team. But I think this is an important goal to think about. Maybe there's a way to narrow it a bit, but it really is a primary goal, right? How do we get our family members out of that state system and into a more supportive tribal system? Finally, we want to increase family functioning and family well-being. Now, if you're a tribal judge from 20 years ago, like I was at one point, you may look at this list and go, wait a minute, that's not what tribal courts do. This looks like, I don't know, like social services and a lot of other things. Well, it turns out, and even the state courts are starting to realize this, we have to all work together and wrap around all of what we do around our people in the system, because they need a coordinated support system that is talking to each other on a timely basis to help them. And that is how we get ourselves to work together to have goals like increase family functioning and family well-being. Okay, so these are the goals for a family wellness court. There's a similar set for a juvenile wellness court and a very different one for a criminal wellness court, which talks a lot about like reducing criminal recidivism, etc. But this is the set for family. Okay, go to the next slide, Ashley. So I wanted to share with you some actual tribal family court models and materials, and we'll just kind of jump in and out of them. I'm not giving you everything because we don't have enough time for that, but there are two models I want to look at. The first is the Lummi Family Wellness Court in Washington State, and the second one will be the Henu Community Wellness Court in Kenai with the Kenaitze tribe. But we'll start with Lummi first because they really focus on the family side as the primary focus of the wellness court and the parents. Let's go ahead to the next slide. So just a little bit about the Lummi court. It's a therapeutic court, and this is all taken from their participant handbook, which they share with parents who are the participants in their family wellness court. So they tell them this program is designed to reunify and preserve families. It provides intensive wraparound services, and it's for participants with substance use disorders. It is a voluntary program, so participants can choose to quit it at any time. So that's a little different than the model I showed you at the front on the diagram. I think if there is a threat to report people to the state system, that is less voluntary. You can set your court up that way, and some do, because it's thought to be a motivator to keep people in treatment longer, and the longer you keep them in treatment, the more likely it is they'll stay in treatment. But other tribes have chosen to make it purely voluntary. Now, we could have a long conversation about Public Law 280 and the lack of Indian country and how the state can still jump in and swoop that parent out of your community into the state system. That can happen. But let's put that to the side for now, because that'll really divert us. Let's go to the next slide. So the vision of the Lummi Family Wellness Court is to reunify and support families, right? And to make sure they're free of drug and alcohol dependence, and to provide for the future of their children in the ways of their ancestors. So they have a cultural element to their vision. Their mission is to promote healing. And they talk about having a culture and treatment centered program. So this is not all just about treatment, it's also about culture. But it's one that integrates essential services and community members. It encourages parents to live healthy, sober lives for the well-being of both themselves and their children. Let's jump to the next slide. So as you can see here, they have their long-term goals that they've modified for their program. So it's important for them to assist parents in receiving substance use disorder treatment quickly. That quickly is a very important word here, because it takes a lot of sort of swinging that giant yacht in the ocean around to, to be able to get someone treatment quickly. So they've set that as a goal to figure out how to make that happen. Also, to support them staying in treatment until they have the skills to stay in recovery. Another goal is safety for children, and to return children home as soon as safely possible. And they want the goal of closing their cases with children living with the parents. Now, they use this term non-parental custody cases. Let me just explain that for a minute. So there's two kinds of family cases that come into a tribal court, right? You have the child maltreatment cases, where someone's alleging that a parent or a guardian has mistreated a child. That's one set of cases. And then there's all the other family cases. People are getting divorced. They're arguing about parenting, or paternity, like who's the parent, or they're arguing over visitation and custody in a marriage or a divorce. Those are a separate set of cases that are not the maltreatment cases. And so they are not the wellness court cases, unless you make it so. Wellness court is usually focused on the child maltreatment cases where a parent or a guardian is alleged to have committed child maltreatment. Okay, and so Lummi is just saying those are the cases we handle. We don't handle those other, child custody cases in a divorce or in a breakup of a family. They also have the goal of helping the parents and guardians in developing the skills needed to prevent child maltreatment and intervention by Child Protective Services. Okay, next slide. So eligibility. So every wellness court team at some point will have to sit down and figure out who they want to be eligible for their program. And I've noticed in the past, we just come up with a list of eligibility factors, but in the more recent wellness courts, I'm seeing a list of who's not eligible. And so this is Lummi's. They're saying it has to be a child maltreatment case. It can't be one of those custody cases pursuant to divorce. That's a separate thing. It only is open for children and parents who are either enrolled in the Lummi tribe or they're descendants of the tribe. Also, the family has to reside within a particular county in Washington, and they have to agree to engage in the services of that county or that of the tribe in that place. They have to have a substance use disorder. They have to agree to all the requirements of the program. They have to be able to fully participate. So if the parent is incarcerated, they're not going to be able to do the program. So that would make them ineligible, unless, of course, they're going to be released in time to participate in the program. Who's not eligible? So again, we see some of the federal requirements here. A parent who's a registered sex offender is not eligible. A parent who has a felony for violent crimes within the last 10 years, not eligible. If they have a pending drug delivery case, not eligible. If they have a current violent felony assault charge, not eligible. Or if their parental rights have been terminated, they're not eligible. So they're sort of hitting all the federal requirements here and some of the state law requirements. Well, I shouldn't speak for Lummi. They may be able to terminate parental rights in Lummi tribal court in the regular docket. And if they do that, they're saying those people are not eligible. Okay, let's see. Let's go to the next slide. So as I mentioned before, wellness courts are really comprised of teams of professionals. And if you decide to write a grant or to launch one of these courts, you need to start thinking about the professionals that would be on that team. So I'm going to show you the Lummi team here. And interestingly, on their team, they include the person who's the participant, the parent, the guardian, and their children and their extended family members. They include them on the team. And so this is an interesting difference from the original adult drug courts. They want these people involved in the meetings that the team has about these people. Also, the judge, the wellness court judge, is the leader of the team. And he or she is the judge that presides in the wellness court status hearings. And they make the final decisions in a case. The wellness court coordinator is very important. This person is coordinating the wellness court team and the participants in it. So they're ensuring that the program is meeting grant requirements. They're collecting information about drug and alcohol treatment on each participant. They're tracking the progress of participants in the phased requirements and the treatment program. They're ensuring that the team is following the policies and procedures of the program. There's also a social worker, and I think at Lummi this is a tribal social worker. And if there is a pending child abuse investigation for a parent, that social worker works with that parent to refer them to services to help them do the things they need to do to get their child back in the home. Also, the goal of the social worker is to help the family achieve safety, permanency, and well-being. So they're also looking out for the safety of the child. And I apologize, the diagram is not showing up here. But what it was sort of the process of moving a case from the regular part of the Lummi Tribal Court into the wellness court. And at the bottom was all the team members. But we can only see the judge and the attorneys here. Let's move ahead one slide. So there are other team members at Lummi, which we may not see in Alaska, in a very small village, for example. But they also have these people on the team called guardians ad litem, or GALs. And these are advocates for the child in a court. You can get federal funding, I believe, to set up a GAL program. If you have that many cases and that many children, it might be worth it. But they really are a neutral voice looking out for the child's best interest in a court. Also, if the parent has an attorney, that parent has a right for that person to have a say on the team, or at least occasionally show up and make the case for that parent with the team. And very importantly, the team has treatment and service provider representatives on it. They can be treatment providers for substance disorder treatment, for mental health disorder treatment. With respect to domestic violence, maybe there are peer support programs. At Lummi, it looks like they also have someone who talks to people about general assistance requirements, TANF, employment and training, and there may be other treatment providers that they bring in for specialty aspects of their treatment program. Okay, let's bump forward one. Okay, so it's about to launch into the case plan here. If you think of any questions about any of this, feel free to pitch a question into the chat. All right, let's take a look at a Lummi case plan. So they're describing their case plan as a roadmap that it inventories our participants' strengths, barriers, and needs, but it also includes that person's goals for themselves. These are the goals that will help them reunify with their child. And then there are services and service providers identified, and they can include any or most of these things in the bullets here. So like I said, there may be a treatment provider for substance use disorders. There is a person who does random drug and alcohol testing. You may have support groups or meetings like AA or Al-Anon or Red Road or gosh, there's another one. I'm spacing all the different kinds of support groups, but there could be support group activities that are included in their plan. Maybe they were assigned to go to parenting classes. Maybe there's family therapy groups they should be participating in. As you can see, there's a lot of different things here, and some of them are very like hardcore treatment kind of things. Other things are support group. Other things are educational. Some things are more like case management, like finding housing for them, employment and training services. There's even mediation assistance here for families. So they've got a pretty nice fat list of service providers that perhaps not every, and maybe I should say most villages in Alaska might not have access to this full list. What I would say about this is don't get overwhelmed by the list. The key for your wellness court is to figure out what you want to prioritize and go after. So you don't have to have the whole list, but there may be 3 things on that list that you're going to work with your team to go get funding for, or go get an agreement to get with another program or agency. At the very bottom, they talk about their plan in this way. They say it is a family-centered plan. The case plan is a family plan. So it's not just about the participant, the parent, or the guardian in the program. The plan is going to be for the whole family. And I know in many tribal communities, this may include the extended family. So that's a really big difference from a state drug court. Okay, go ahead and bump forward one, Ashley. They also had this diagram for their case plan, which I thought was interesting. So they give this diagram to their participants and they ask them to write in on this. But you can see for our purposes that the case plan is not just treatment. It's also health, like do you need to go see a doctor? It's about school and work. It's about visitation with the children. It's about culture and a mental health. And it's also about the person, what that person needs that's in the program. And it's holistic. And it's working with that person to develop the plan for that person. All right, let's go one slide forward. So usually in a tribal healing to wellness court, we have phases, and you'll see a chart with phase 1, first 3 months, phase 2, next, it's usually like 4 months, 2 to 4 months, phase 2, and then there'll be 4 phases. But the Lummi program talks about these as milestones or milestone phases. And I thought it was interesting to look at the things they're focusing on in each phase. So look, it's all about parenting. In milestone 1, supervised parenting time. And then if they graduate from that milestone, in milestone 2, it's about monitoring or monitored parenting time. And then by 3, it's unsupervised parenting time. So they're really giving them skills to learn how to do these, learn how to parent, and then graduate with that skill set, and then they go on to the next set. Eventually you get to a milestone where you can parent without supervision, and then you can parent overnight, and then you can have more overnight parenting, and then ultimately you get your child back in the home and the case is closed. So the Lummi program is really focused on parenting. It's the central backbone of their family healing to wellness court. And when we look at Henu in Kinaitsi, you'll see different, because theirs is really, I think the backbone of that program is focusing on getting people to not recidivate crime. But not this program. This is way more parenting focused. So you can kind of tilt your wellness court in one purpose direction or another. Okay, so they say the purpose of the milestones is to support the participant in building recovery and reunifying with children. And they say that it takes different amounts of time for different people. It depends on each person's circumstances and how they progress. Okay, go ahead and bump forward. So for each of those 6 milestones, Lummi has a task list. It's a form that they give to the participant. And I tried to shrink it down for you. It looks like Ashley might have shrunk it back up here. I can see it better on her slide here. But as you can see, when a parent or a guardian is about to graduate from one milestone to the next, they get a task list. And they have to initial it on the left side. And then the court coordinator has to initial it on the right side. And the court coordinator has been keeping track of, did you go to your counseling sessions? Have your drug tests come back clean? Have you been doing your visits with your kid, and how is that going? So it won't be possible for someone to just check off everything as it looks good without the coordinator double checking it and the team double checking it. So what kind of things are they expected to do? Well, they're expected to attend their court hearings under family treatment court in the first box. They're expected, I'm just going to pick at these. They're expected to meet with the coordinator weekly. If we look down in the treatment box, they're expected to attend their one-on-one meetings with their substance abuse treatment counselor. Or maybe they're going to groups, support groups. Mental health treatment, they've completed their mental health assessment. And then there's a child welfare box below that. They're meeting with their social worker weekly. They created a safety plan and a monitored parenting time plan that they're following through with. And then parenting, they've completed their parenting assessment. They've attended their parenting classes. Housing, they've started looking for housing. General assistance, they've signed up for it, and they have a case manager. So you see, these tasks are like baby steps that they're being sort of coached through and monitored through. And once they graduate from one phase, in a sense, then they can go on to the next one. So I'm going to show you the very first one and the very last one. And remember, there's 6 of them. Go ahead forward, Ashley. So in order to graduate from the entire program, this is the graduation checklist for LUMI. So for court, they're still having hearings that they have to attend. They still are getting drug tested at this point, and they should be coming back clean. They should have a relapse prevention plan by the end, like, you know, what skills do I need to stay away from drugs and alcohol? Have I learned how to do that? Do I know what my triggers are and who to avoid? And what do I do if I'm in a difficult situation? There's still some treatment going on here at LUMI that they have to attend treatment sessions, etc. And maybe there's still some mental health treatment appointments. They may still be meeting with the social worker on their safety plan for their child, finishing off parenting classes, reflecting on skills learned. They should have safe and stable housing at this point. And then they should be signed up for all their general assistance and their education and training and TANF money. And their children should be attending all their medical and dental appointments and be attending school regularly or daycare. And the parents should be working with the teachers. So, you know, it's after looking at these task lists, I started to think, oh my gosh, this is like, as a parent, when I have a teenager, right? So I'll have a little sheet of chores that he's supposed to do, like things he needs to think through and do every day or every week. And I tack it on the wall and it has little check boxes on it. That is literally what these teams are doing for parents who have substance use issues. It's like they're a giant teenager in a way, and they're working them through not only building skills, but providing them support in areas where they really need it and they don't have it. And then at each level, they step up more skill and more responsibility until they graduate from the program. Okay, I've been blabbing a lot. Somebody ask me a question, even if it's Ashley.
I wanted to note, and I'm so thankful that you mentioned the CASA gals, the guardian ad litems. This is so important in the family healing to wellness courts, and there is funding out there. So if you need support in that, I am more than happy to find those solicitations. It is in the best interest of the child and family, and helping that family not recidivate, right? And so when I saw that, that kind of spoke to me a little bit. If there are any questions, this is your time now. It's 11:30, and at 11:40, I'll give Judge Pat the kind of 10-minute warning. And at 11:50, we'll be doing a survey and closing in a good way. Anyone have any questions for us at this time?
If there are none, Ashley, go ahead and move forward a slide.
And if there are any questions, feel free to interrupt us or use the chat box.
So a lot of you are probably going to be interested in knowing more about Kenaitse's Henu Community Wellness Court. This is what they call a tribe state or a state tribe joint jurisdiction drug court, and it's our Alaska joint jurisdiction court. Kenaitse is leading the way in the joint jurisdiction work, and I'm going to describe to you some of the parameters of their wellness court because it has a family, it's a hybrid, and part of what they do is a family drug court. Go ahead and bump forward one. So they call it the Henu Community Wellness Court, HCWC. Their vision is to transform lives for a healthier community. And their mission, I highlighted wellness and rehabilitation. So they are focused on wellness and rehabilitation. And their top priorities are treating and healing substance use, restoring participant ties to the community, restoring participant relationship with family and friends, increasing self-sufficiency, breaking the cycle of recidivism. So this is one we didn't see in Lummi, because Lummi wasn't dealing with people who were alleged to have committed or pled guilty to a crime. But Henu's court, the Henu court combines a DUI drug court with a family drug court. And so they handle DUI cases as well. I shouldn't say they handle the cases, they handle the wellness docket attached to those cases. Their other priorities are to place children in safe homes and to give back to the community through volunteer efforts. So interesting choice differences they've made between Henu and Lummi. Okay, go ahead and move forward. A little more on Henu. So in 2017, the Kenaitze Indian tribe and their tribal court and the state of Alaska court system, on behalf of the Superior Court of Kenai, launched their joint jurisdiction court. And this particular joint jurisdiction court falls into the category of what they call co-development, meaning that both the tribe and the state work together to build this and to launch it and to operate it. So like I said, it has elements of an adult criminal, family, and DUI drug court all in one. They collapsed different wellness dockets basically into one. Their target population includes individuals who are dependent on drugs or alcohol, and they can't have recent charges involving violent behavior. They also accept families with open child welfare cases in the state system, not the tribal system. Now, the other interesting thing about Henu is they serve anyone in their service area, not just tribal members. They serve anyone in their service area who meets the eligibility requirements. And most of their participants and most of their graduates, at the time their court was evaluated a couple of years ago, were not Native. So it's an interesting service that Henu is providing to the larger community in Kenai and the neighboring region. Okay, go forward one slide. Oh, okay, I just said that. So they serve participants living within the Kenaitze tribal service area, regardless of tribal membership or race. Oh, and this is interesting. The kind of joint jurisdiction court they're operating is one where the state magistrate or judge jointly presides over hearings with the tribal judge. So you can see them at the table here. Both judges sit side by side, and they handle the wellness court status hearings together. I know a lot of tribes in Alaska do panel judging with 3 judges, so maybe this won't seem so odd. But to those of us in the lower 48, that's kind of, it's both cool and surprising that you'd have the 2 judges, one state, one tribal, working together. It's laudable. That takes a lot of coordination and co-development. Okay, let's jump ahead one slide. So this is some of the technical stuff behind Henu, and I just share it so that you see how it's different from Lummi. So Henu is what they call a post-plea pre-sentence drug court. That means that in order to get into Henu's court, you had to have pled guilty to something. And before you're actually, it may be that the sentence is delayed or suspended is the word. The sentence is suspended in state court. So we don't have that in the Lummi Family Wellness Court because we're not dealing with crimes in that court, in that wellness court, but you are in this one. And so participants had to have engaged in a Rule 11 sentencing agreement. And if they graduate successfully from their wellness court, they get a more favorable resolution in state court sentencing. If they are terminated from the wellness court, they get a less favorable resolution, which is probably whatever sentence they would have gotten if they hadn't done this at all. They do characterize it as a voluntary court, but I would argue with that because there's something hanging over their heads if they don't graduate in the state court. Lots of consents are required to get into this as a participant. You have to have the consent of the state district attorney's office. Of course, the person who would be a participant has to consent. And also the state of Alaska court judge has to consent for, and this is not the judge that sits in the wellness docket. This is the criminal court judge that sends the person over to the wellness court. So in the diagram on the right, I just point out that this kind of wellness court requires memorandums of agreement between the state and the tribe. The Henu court is just moving cases from, in the left box, from state court to the joint wellness court in the middle box. But what it doesn't do is move cases from tribal court on the right-hand side box into the wellness court. That requires a piece of law, tribal law, like a children's code or a juvenile code or a law and order code. And lots of tribes in Alaska are not fully exercising their sovereignty in doing that. It may be about money because it costs a lot of money to put all that infrastructure in place tribe side. But I would urge tribes to consider building in that right-hand box and moving cases directly into their own wellness courts. Okay, Caroline, I see your little yellow hand.
Thank you. I had a follow-up question. When you're saying Rule 11, that's a criminal case, correct?
Yes. In state court.
In state court that's being concurrently resided over in the Henu court.
Yes.
Correct? Okay.
Yes.
So there is going to be charges. So like we talk about some of our, sorry about the loudness, I've got construction going on in here, but we've talked about some of the healing to wellness courts like you were just talking about, where they can directly go into the court so that there is no permanent charges on their record, right? Those are lower level healing
Yes.
and wellness that you were just talking about. And that requires the codes and the permission to handle those sorts of cases.
Yes, basically your tribal council needs to authorize your tribal court to do it through a code. And of course, in those codes, you create job positions, right? Like a case manager or wellness court coordinator, and then you have to go get money to pay for those positions.
So like different cases that need to be in the codes, I was talking to another grantee earlier, would be like, you were talking about ICWA, right? To be able to handle ICWA in one of their codes. Or what about adoption? Would that need to be in their codes as well? Tribal
Yes.
adoption?
Yes, you want to have what they call a dependency code. In the states, they call it a dependency code, but tribal courts tend to call it a children's code. So you need those provisions, and you can attach an adoption set of language to that as well. Lots of tribes in Alaska have the adoption provisions, but they don't have the dependency provisions. That's
Some of them don't.
Yeah.
Where would they go to get help with that?
Me or some of the people that we farm out from Rural Cap. So, but you're saying, is there a template somewhere? Yes, I can find templates. By the way, Barrow, Native Village of Barrow has a pretty good dependency code and juvenile code, and they're a useful starting point to look at.
For the adoptions and all the
Yes.
others. Okay, great. Thank you.
All right. Who usually develops codes? It can be anybody. If you have an attorney for your tribe, they could do it, or your team could work together on drafting it with your TA provider. That's Rural Cap, if it's Rural Cap, or Tribal Law and Policy Institute. I do code development work also. So your team can work with a TA provider to do that, and then you can run it through your attorney and they'll make some tinkering with it, and then it can be adopted at that point. Okay, let's go to the next slide. So I show you both, I show you phase one of Henu's phase plans and the graduation phase, just so you can see it. You see they have their traditional values wheel on the right. They teach their participants these values, even if they're non-native, and it seems to be very useful. So, I mean, it's just interesting. We're all human beings, right? And we all have human needs, and it's proving useful for them to get people through recovery. And they've incorporated their values into their wellness court. So they have a lot of plans at Henu. They have crisis intervention and safety plans, a life change plan, a China case plan, that's child in need of aid. Then you see the assessments for substance use disorders, treatment, testing, functional behavioral assessments, mental health assessments, mental health treatment, attending court, having a sponsor, having a cultural sponsor, participating in circle process or a victim impact panel, spiritual and cultural assessments, family mapping. Now, I'm guessing that not everybody does all of these in their personal plan. I'm guessing that it's sort of, they're assessed about what they need to do, and it focuses them more on certain parts of these bullets. But we'd have to talk to someone from Henu about how they hand this out participant by participant. You can see they also have seasonal activities, naming ceremonies, journaling. They ask their participants to write about, reflect in writing about the experience. And of course, they apply incentives and sanctions. They have requirements to move from one phase to the next. So at the very bottom on the left-hand side, you see they have to have 60 days of sobriety to move to the next phase. They have to have been following all their treatment recommendations, attending all court appearances and meetings, and they have to have safe and sober housing. So with requirements like that, a program better be helping people get housing, because you don't, and I'm sure they are, you don't want to require someone to do something that you can't help them actually do in real life. Let's look at the graduation phase. Or criteria. So there's a questionnaire they have to fill out, which I'm sure requires them to reflect on how they've grown and what they've learned. They have to have a relapse plan, because once they graduate and leave the program, they're on their own again. It'd be real easy to start drinking again or using drugs. And so they need to have a strategy that they've already put together and put in place before they leave the program. Housing, work, school, volunteer efforts. Interesting that they have them do a service project as part of their whole program, and they have to have completed it by the end of the program. They have to have 180 days of continued sobriety, a life change plan, again, treatment, court, meetings, and once they've fulfilled all their obligations, they graduate. And I didn't show you all their phases just for time purposes, but you can see them in the Henu Policies and Procedures Manual, and we can get you a copy of that if you let Ashley and Caroline know. Okay, let's bump forward. I wanted to talk just for a moment about the national standards. So there is a document called Family Treatment Court's Best Practice Standards. And it's easy to Google it. Maybe Caroline can find it and link it up here shortly. Go ahead and go to the next slide. So these were developed in 2019, probably by, let's see, this was an OJJDP grant, but, and it's with National Association of Drug Court Professionals. So basically, nationally, they're trying to identify the key things that every family drug court needs to do to be a legit family drug court. In other words, to make it actually work. And And so under the first standard, they're really looking at how you organize and structure your program. As you can see with Lummi and Henu, there are very different ways to structure them based on what your community needs. So there's some creativity and tailoring that goes into this, but are there certain elements that you have to have? For example, maybe drug and alcohol testing needs to be part of every drug court or it won't maximally work. They also look at the role of the judge. You know, is your judge more like a coach or a mentor, or is he or she more like a regular judge, right? Who decides what facts are true. And the third standard is ensuring equity and inclusion. Interesting thing, the early drug courts, which were adult criminal, they usually got mostly white participants in the drug court program. And the minority participants were not there. And so a lot of people were standing back and thinking, well, that's not fair. You're sending the people of color to jail and you're sending the white defendants to drug court. And so drug courts have had to take a really hard look at this. And remember when I said lots of our people are in the state systems? Well, if they're not popping out the other end in drug court, we've got some big questions to ask about the state drug court programs. Or better yet, we just open our own tribal programs and make sure they come into our programs. So anyway, standard 3 is looking at that problem. Standard 4, early identification, screening, and assessment. This is the #1 trouble area for our tribal drug courts and probably for state drug courts too. Can we get the screenings for substance problems done and the assessments for mental health problems? Can we get those in a timely fashion in our villages and tribes? Because that launches the whole drug court program right there. Standard 5, timely, high quality, and appropriate substance use disorder treatment. There has been a lot of advancement in the treatment of addiction and brain science in the last 25 years. And even the state systems has not fully updated their treatment approaches to the state of the art, and neither have tribes, although some are in the drug courts are doing it. So this is standard 5 would be really important to look at when you're looking at what treatment you currently have and is it up to that level of what we know works? Or do we need to go get more money and bring it up to that level? Standard 6, comprehensive case management services and supports for families. Just that is a critical thing to have in our drug courts and our wellness courts. Standard 7, therapeutic responses to behavior. This is what they're calling incentives and sanctions that are applied in the status hearings by the team for each participant. In juvenile drug courts, they also call it contingency management. But I like to think of it as behavior modification, right? You're giving rewards when they do something right, and you're giving graduated sanctions if they're failing to do the things they should be doing. 8, monitoring and evaluation. For me, as a tribal judge, for me, this is, have we really identified our long-term goals and how are we getting to them? Are we actually getting to them? Are we achieving them? And if not, what do we need to do? How do we need to change our tribal court or our wellness court, tweak it so that it helps us get toward our goals? And of course, evaluation is evaluating, have you actually pulled it off and achieved your goals? And that's usually done by an outside evaluator. Okay, so I think I've thrown everything at you in the kitchen sink. Are there any comments or questions at this point?
Judge Pat, I don't see any in the chat box, but we can. Oh, and thank you, Caroline, for uploading that content. I don't see any questions at this time.
Okay. In that case, I will turn it over to you, Ashley.
Great, thank you. And I'll skip forward here. Perfect. Right on time too, Judge Pat. So we'll go ahead and take a survey. I could also email this to you and we'll upload it into the chat box here. We do a survey just to gauge, the information, how you've been able to take that information on. And then also it helps with our funding to be able to do this work. If we're able to go back to our grantors and say, the responses were good and they want to continue this work, then we'll continue to get funded. So we'll upload that survey into the chat box and I'll also email it to you. So if you haven't already, please put your name, where you're calling in from, and your email in the chat box. And also, we wanted to thank Judge Pat, Chief Justice with Hopi Appellate Court, for doing this webinar today. Big thanks. This was talking to my heart, soul, and all the work that we're doing, not just at Rural Cap, but also just in our communities, and that our children will know different. Having two babies, we're setting them up for change. So thank you, Judge Pat. And also, if you have questions for Judge Pat or for us, feel free to reach out. Here is her information. And then also thank you to my colleague, Caroline, who is also mediating the chat box and comments. And then this is her information. So Caroline, if you wanted to add anything to your piece here.
Liana, for your time today. Please know that our trainings here are directed by you. The questions we receive from you. So please feel free to reach out to us via email or phone so that we can help you enhance your tribal courts in any way that you need. Liana Juknuk.
Thank you, Caroline. And though I work under the resource basket, I work closely with Alaska Tribal Justice Resource Center. We are under the Rural Cap umbrella to be able to do this work and work with amazing people like yourself. We're going to close in a good way to wrap up our day. And we had started our day with a good intention and hopes for the future. And Caroline, if you may, please close us in a good way.
Liana, my intention at the beginning of this webinar was public safety. It's been on my mind a lot lately. And after listening to everything that Pat has said today regarding healing to wellness, I know she used the term drug courts a lot, but we're really focusing on healing to wellness and restorative justice in our communities, not only for the people that are in front of our court, but for the whole family so that we can have healing for our community. And it really speaks to my heart. So Liana Juknuk, Pat, Judge Pat, I really appreciate your time and your expertise. I hope that she has answered a lot of questions. I know she's brought up a lot more questions for me so that we can get this set up in a lot of our smaller communities. These healing to wellness courts can only offer more healing for our communities. So, Liana Juknuk, for your time today. And if you have any questions, please reach out to us. Yuha.
That is the end of today's webinar. Thank you for spending 2 hours with us and going over this very important information. And I'm just so excited for what's to come for this next generation and for our communities and our villages. And if you have any other questions, now is the time. We'll stay on and we'll make sure to drop the survey in the chat box and email it over. Please do that so that we can share this information with Judge Pat. And thank you. We are just about 4 minutes early with closing. And so feel free to pop off or use this time to ask any questions that you may have for Judge Pat.
I will stick around for a little bit just in case.
I did put the survey in the chat box, so please click on the survey and complete it. Thank you.
Caroline and Ashley, did you want to, just checking to see if anybody, it looks like people are popping off. Did you want to meet post recording?
Yes, and I'll stop recording here in just a few minutes in the chance someone had a question that we needed to address for future participants. So we'll give it just 2 more minutes. And it looks like Crystal might be the only one on. So I'm going to go ahead and exit out and stop recording here.